Welcome to our YouTube video series on business law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we will be discussing the non-competition clause. Now, a non-competition clause is a restrictive covenant that is often found in certain business agreements and even employment agreements. And it is a very significant and strict restrictive covenant in the sense that it precludes outright from competing with another party. And as such, the standard is very high to achieve enforceability, and it is very easy for parties to ask too much by way of a non-competition clause, especially where a properly drafted non-solicitation clause might suffice, or a lesser non-competition clause might be more than adequate. Now, the problems that arise from a non-competition clause are primarily seen when there is inequity in the bargaining power of the two parties, such that the party seeking to enforce the non-competition clause is bargaining from too great a level of strength. Hence, in employment agreements, one has to be very cautious as to the imposition of a non-competition clause. Yes, in certain circumstances where the person that is being bound by the clause is of a sufficiently high level, there may be certain opportunities to have this clause be enforceable. However, simply imposing it upon all employees is going to come across as too broad and very likely lacking in enforceability. The same even would apply with respect to the corporate sense, because in certain circumstances, trying to impose a non-competition clause could be deemed excessive. However, where one is selling their interest in a business to another party or to one's former fellow shareholder, a non-competition clause could be very apt. But once again, as with everything, you need to be cautious of not overreaching with these clauses. And the two primary areas of overreach are with respect to its time duration and its geographic extent. As such, you don't want to have the duration be for too long. 18 months to 36 months is around the reasonable limits that you should find, depending on the circumstances. Similarly, with respect to geography, you need to be cautious depending on the circumstances. If you're a doctor or a dentist and you have a young associate, you don't want to preclude them from engaging in business outside of departing the city in which they are presently engaged. Putting too excessive, too expansive a non-competition clause as respect to geography and restrictions can see the clause kicked out by the courts. And you can also see parties not adhering to it because it is unreasonable from the outset. So these are considerations you have to take into accord when you put in place a non-competition clause, and even when one is in place, how and if you seek to enforce it to the degree that is provided in the agreement. Thank you.